Welcome to Employment Law This Week. I'm George Whipple. First up, NLRB General Counsel Peter Robb considers changes to the way the Labor Board processes cases. This comes in addition to proposed changes to the organizational structure that we reported on last week. According to Robb, changes are necessary to adjust to declining budgets, reduced caseloads, and imbalances in staffing in the board's offices. Critics question whether they are driven by other considerations. Robb expects decisions to be made by late summer. When will the EEOC respond to Me Too? Acting EEOC Chair Victoria Lipnic says soon. The Commission has announced plans to release new sexual harassment guidance. Speaking at an NYU Law symposium called Avoiding the Next Harvey Weinstein, Lipnic said that much of the current guidance dates back to the 1990s. In November, the EEOC announced revisions to the draft guidance in response to Me Too. Lipnic said these have now been sent to the Office of Management and Budget for approval. Kate Rhodes has more in our continuing coverage of Me Too at Work.
The content of the new sex harassment guidance can likely be informed by a 2016 task force report issued by the EEOC following 18 months of study on the issue of harassment in the workplace more generally. It issued a few best practices that I anticipate seeing in this new guidance, which includes more individualized training on anti-harassment and discrimination procedures in the workplace. It also mentioned increased training for frontline managers and also bystanders, for people that witness harassment or receive complaints about harassment but aren't the subject of the complaint or the complainant themselves.
Justice takes another look at False Claims Act litigation. Two internal DOJ memos suggest that the government may be reconsidering its approach to FCA cases. The first memo provides guidance on when DOJ attorneys should consider affirmatively dismissing a whistleblower claim rather than simply declining to intervene. The second memo asserts that DOJ attorneys may not use agency guidance as a basis for proving an FCA violation. George Breen has more on what employers should take away from these memos.
I don't think the memos in and of themselves change the risk for board members or executives. I think that risk continues to exist. The reality is, however, that both memos provide tools for those individuals and their counsel. They ought to actively use those tools when they're faced with litigations and investigations. Unfortunately, the risk remains. Since 2015, there has been an increased focus by the Department of Justice on holding individuals accountable. Those risks are real. But what I think the memos provide are additional tools for their counsel to say, this is not the right case to bring.
Now it's time for our tip of the week. Paula Wernicke, Senior Legal Counsel for Adidas Group, is here with some advice on best practices for managing a combined human and AI workforce.
So it's all about digital. Combining the two workforces, the human workforce and the artificial intelligence workforce, needs to get on the track of, for example, within Adidas, our people strategy and the 3 C's. The 3 C's are about creativity, collaboration, and confidence. Therefore, creativity needs to be focusing on what do we, from a human workforce perspective, need to change at our mindsets and getting the artificial intelligence within our day-to-day business. If you're getting to the next step, collaboration, your employee needs to be ready and upskilled working with this new artificial intelligence systems. So last but not least, getting back to the Adidas people strategy, we have the confidence. You as an employee always need to be confident. You are the one who has the idea. The idea is not laying with the artificial intelligence, not now. But right now, you are the one who gives power to this new digital strategy.
Thanks, Paula. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.